Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Well, hello everybody. Welcome to another episode of Empowering Plans Podcast with the FIA Group. I am Ron E. Peck, your Chief Legal Officer of the FIA Group. Behind the deck is Pat Santos. Hey, Pat, the producer with the most. Pat, I got to tell you, if somebody said what the number one issue, with the number one sort of regret I have when it comes to the COVID pandemic and everything, the legacy of the pandemic and sort of the move from in-person work to virtual work, I would say it is without a doubt these podcasts and webinars that are done virtually rather than in person in the studio, because as a result, I don't get to spend time with you, watching you do your magic behind the mic, behind the machine, mixing it up, breaking it down. You're like a DJ, you should be famous out there with the headset on. Way underappreciated, Pat. So thank you for all you do. And speaking of another person who I believe could never be adequately appreciated is our consulting attorney, Nick Bonds. Nick, or should I say Nicholas Bonds, right? You want to be professional?
Oh, Ron, please. Nick, for the love of God.
All right, you got it, Nick. So, Nick, listen, buddy, we'll keep your name short, but we'll keep the discussion long. I'm just kidding. Florida, it's funny. Once I start the conversation with Florida, everybody sort of perks up and goes, oh, this should be interesting. Florida has gotten slammed lately. Depending on when you're listening to this podcast, folks, they've been through a couple of hurricanes. They're rebuilding, and I'm sure there's another one on the way by the time you're listening to this recording, depending on how quickly Pat can get this up on the internet. But the point is, Florida is a hotbed for activity, whether it's weather activity, climate, theme parks. I know Universal Studios is opening another big theme park. I mean, man, oh man, things are going on in Florida, right? And one other area where there's been some activity is in the area of case law, right? Some litigation, and in particular, litigation regarding the No Surprises Act. It should be no surprise that the NSA is on the tip of our tongues today, Nick. Yeah, you're welcome. I did that. And, in particular, when it comes to the NSA and litigation in Florida, it has to do with what I think is probably one of the most interesting areas of healthcare and healthcare expenses. Am I talking about specialty drugs? No, I'm not. Am I talking about oncology? No, I'm not. I'm talking about air ambulance, med flight. Man, oh man, it is one of those things where it is dramatic, it is impressive, and it is expensive. And I remember, right before and around when the NSA was first being passed, there were articles, I can't remember which magazine or magazines it was in, but there were all these exposés being written about the cost of air ambulance and people being balance billed and these costs and all the rules and laws that apply to them and how they charge. And so it didn't really come as much surprise when air ambulance, MedFlight, earned its own shout out in the NSA. I mean, it was one of those things where I bet MedFlight's parents were like, that's my son. Look, there he is. He's famous. Because when you look at the NSA, it generally was talking about more sort of generic, ambiguous, big types of care, right? Out-of-network specialists at an in-network facility, emergency care, right? Very sort of generic or broad terminology. And then, boom, they hone in on a very specific area of healthcare or service, that being air ambulance, med flight. So, it should come as no surprise that as the NSA continues to roll out and we see sort of case law and disputes arising from it, that we were going to see something that relates specifically to air ambulance. And today, I know you want to talk about that case, Worldwide Aircraft Services, Inc. versus Worldwide Insurance Services, it's LLC. It's a 2024 case, so it's recent. And it's very interesting because for those of you who think you're about to hear about strategies to take down med flight and air ambulance and pay less and avoid balances and all this, this is a case that kind of defines where it was dead on arrival. It failed to launch. So, Nick, I don't know if you want to give a little bit of background about sort of what this case is about, sort of what brought us to the courthouse, what happened before the case was even filed. Like, what's the background on this?
Sure, Ron. Yeah, I think this is one of those cases that failed to take flight. Basically, there was a fixed wing air ambulance provider operating out of Florida where they were hired to transport an individual from the Dominican Republic back to Florida. That's a flight of almost 1,000 miles, if I'm not mistaken. After they transported them from the DR to Florida, the air ambulance provider sought reimbursement from the travel coverage company that was licensed by a major, insurance provider down in Florida to offer travel health insurance to its participants to handle claims for individuals that arise outside of the United States. So, a travel insurance benefit, basically. The air ambulance provider ultimately wasn't getting anywhere with their claims. They basically more or less exhausted all of their options with the plan. And so they resorted to everyone's favorite, the IDR under the NSA. So they initiated an IDR claim. It seems that the travel coverage company basically didn't participate in the process at all, didn't respond, didn't submit their QPA, didn't do, most of the things we try to encourage people to be as proactive about doing to comply with the NSA and the IDR requirements. As a result, the IDR entity awarded this provider over $200,000 an award at IDR. And from there, the AA provider, they decided to take this case to court, basically to affirm their award from the IDR entity, which kind of is what kicked off this whole case.
So before we jump into the specifics of the arguments that were made in court and how those turned out, I think it's really important to take a moment and learn from history and, look back at what this payer did or didn't do that sort of resulted in them ending up in court in the first place. And, it's funny because I know a lot of people that their approach to whenever there's sort of an issue is, see no evil, say no evil, hear no evil, right? If I cover my eyes and I hide my head in the sand, maybe it'll go away. And if there's one thing that we've learned about, air ambulances, med flight providers in particular, it's that ignoring it won't make it go away, right? And so, we have allies in the industry. We work with health benefit plans, and frankly, we work with many travel insurance companies as well, carriers that are providing tourism benefits, particularly to students and to employees who are traveling abroad for their company. And yeah, this type of thing is going to happen, and it's important to monitor and respond to these NSA claims as soon as they're received, right? And, for those who think, well, I'm just going to pay the QPA right off the bat, you're not required to do that, right? You want to pay something that the max allowable as defined under the plan, which may in fact be different and frankly less than the QPA, but it's important to, one, pay the benefit in accordance with the plan, whatever that is, be able to justify that amount, and if and when there's a dispute, particularly under the NSA, but I'm going to say really any dispute, you respond in a timely fashion, you assert that justification, that defense, and you prepare for a battle as needed. Ignoring it and hoping it goes away is really very rarely a great strategy. And it's one of those things where if you think, well, if we end up in court, I've got these really killer arguments, don't always bank on it. And Nick, you want to tell us a little bit about, they're in court. What arguments did this payer make, and what did the court think of those arguments?
Yeah, so the travel company here, basically, they kind of did exactly what you alluded to there. They sort of buried their head in the sand, and they were essentially trying to argue, and I think these are probably some of the weakest arguments they could make in this situation, but they went into court basically arguing that the air ambulance provider didn't give them proper notice that was initiating IDR. Basically, they said they never received a notice. And then they tried to argue that they weren't a health insurer that's subject to the NSA at all. So they tried to get it just completely vacated on those grounds. And the court did not really brook with any of those arguments.
So the one I like about with the notice, and again, I don't want to make it seem like I'm bashing the defendant, the payer in this case, because I can empathize, right? I totally see how these types of things may happen. When it came to actually being notified, their argument was basically that the provider had communicated with them, submitted the claim, asserted their dispute, tried to trigger the NSA process by emailing a sort of general inbox that wasn't regularly checked. I guess the individuals that do check it were not sort of aware what to do with this type of correspondence. And so as a result, it was that, well, they sent it to the wrong email address. And it's kind of funny because, well, I shouldn't say funny because it's not, but I can imagine that happening to us. I can imagine it happening to anyone. It's like there are just so many different inboxes and emails and, depending on the purpose or the use, right? Check any website's privacy disclaimer and it says, oh, for questions about privacy, click this inbox. Where does it go? Nobody knows. Or info at this, or questions at that, or support at this. And it's your IT team that's going to help somebody with a website that's not going to load. And those are all open doorways, if you think about it, for an outsider to say, well, I accessed your organization. It's on you to ensure that every possible inbox and recipients on the other end of those inboxes are aware of this type of correspondence and know what to do with it, that nothing is ignored and everything's handled in a timely fashion. And so this is a wake-up call, I think, because a lot of those who are listening to this podcast right now probably have some generic email addresses that they set up or inboxes that they set up for marketing purposes, for sale purposes, for tech purposes, for tech support services, the website, whatever it is, not realizing that that could be a potential backdoor into your organization that a provider might try to take advantage of when it comes to notification about the NSA and the disputed balance. Is that right?
Yeah, essentially the court looked at the email address that the company, held out to the public as a means of contacting and communicating with them, and said that a payer can't argue that they weren't reached out to at an email address that they monitor regularly. The payer here couldn't even argue that, hey, we don't own that email or we don't check that email. Their only justification was essentially that, oh, that email, we don't look at it frequently. We didn't notice this IDR notice come in. And the court basically said that you can't hide behind that to shield yourself from an IDR notice. So the court really did not extend much sympathy to the payer in this situation, and basically said that because the provider sent notice to an email that the company itself admitted that they do own and that is used to contact them with, claims related inquiries, that essentially was no defense at all to failing to participate in the IDR process.
Oh dear. So, but luckily, Nick, they're not a health insurance carrier, right? So, none of this really matters. NSA doesn't even apply to them, right?
Well, that's another one of the arguments that the travel company tried to make. And again, the court did not truck with that. The court basically looked at their website and pointed out that on their website, they hold themselves out as selling travel insurance and international medical coverage, and specifically say that they are here offering a travel and health coverage benefit. And basically, because of the posture of the parties, because it was the travel company that was trying to argue that the NSA didn't apply to them, the burden of establishing that fact rested with them, and they simply failed to establish that burden. And so the court basically said, no, you can't get out from under the NSA this way, and you can't argue that you didn't get the notice because you didn't check your email, because you left the provider on red, that you can get out of the NSA.
So, one of the last sort of underlying storylines that I take from this lawsuit and from the court's decision in this instance is that the NSA and the balance bill disputes that are arising under the NSA, it feels like they're like a hot potato and nobody wants to be the one caught holding it. And, I think for many in our industry and beyond, there was this theory that if an arbiter, under the NSA issues a decision that seems unjust, unfair, just not right, that there's always that opportunity to challenge it in front of a court. And I think that just as we try to resolve NSA disputes within the NSA process and not let it get to this point and escalate, which again doesn't mean you take whatever's offered, but that you need to engage early, you need to come at it guns blazing, and you need to have really great arguments prepared and ready to go day one, rather than sort of hold your punches and wait for it to escalate. Because by the time it escalates, i.e. to a court, as it did in this instance, it may be that the court says, I can't be bothered with this, whatever, I don't want to make a decision, or I'm just going to agree because it would take more to overturn it. I was just watching an NFL football game with my son, and there was a penalty, and they were, trying to determine did he, didn't he? And I said, the rule is there needs to be sort of this overwhelming evidence in order to overturn the call on the field. It's sort of the same thing here. You really need to have that overwhelming evidence in order to overturn the call, because they just don't want to be bothered and become sort of this second layer review on every single case. with that sort of being the understanding here, that's always a possibility. What lessons learned, Nick? What would you say, having looked at this, talking to organizations that are potentially susceptible to the NSA, who maybe were thinking that, that the court's function is this backstop. The court reiterated standards that need to be met in order to have a court really overturn it. And they're pretty extreme. Do you want to talk a little bit about some of these sort of in order to overturn the arbiter, the IDR, the arbiter's decision under the NSA? What kind of standards do you need to be able to present to a court?
Yeah, the court here basically pointed to the provisions in the NSA that really sort of stand for the proposition that the IDR entity's determination is binding on the parties. The court basically looked at that and said that, judicial review of an IDR determination is theoretically possible, but it is a very narrow review and it's only available in very particular circumstances. The court only has the authority to try to even overturn or even to review an IDR determination, basically where there's evidence of fraud or corruption, like a situation where one of the parties outright lied or misrepresented the dates or the timing or the payments or the services that were provided, or a situation where the IDR entity themselves grossly overstepped their authority. But outside of an extreme situation like that, the court basically said that review is not available at all. And basically the court looked at the situation here and just threw out all of the defendants' arguments that, one, that they should have this available, and two, that they weren't subject to the NSA. And I think it's actually interesting that we're seeing the Florida court come to a relatively moderate decision here, because we've already seen cases on IDR coming out of the Fifth Circuit in North Texas that have said that basically there's no ability to judicially enforce the NSA at all. There was a case earlier this year, I think in March or maybe it was May, in Texas, where the court basically determined that, there's no way to judicially enforce IDR determinations, essentially trying to pull the court out of the IDR process entirely, not even acting as a backstop. So I think the marker set down here by the Florida court is one that we would hope more circuits would take, basically saying, yeah, the court will step in where there's something, egregiously wrong at one stage of the process, or somebody's, acting in bad faith. But outside of that, the ability to, turn to the courts to enforce an IDR determination or to fight an IDR determination is going to be severely limited in most circumstances.
So, Nick, bottom line, if I'm a payer and the NSA potentially impacts me, it makes sense to keep an eye out, monitor the claims, watch out for disputes, be aware, and take action early and aggressively. Probably best idea, best practice would be to have a partner who's familiar with these claims, familiar with this process, as an ally day one. Do you think that makes sense?
Yeah, absolutely. The best approach is probably as close to constant vigilance as you can muster. And if you have, professional, well-informed people who can help you do that, people like the FIA group, that's probably where you want to be.
Nick, how'd you know where I was going with that? Listen, I don't want to touch the NSA, but we got some people here who are excellent when it comes to it. And when that claim came in that email, if this payer had been a client of ours, I know that it would have been addressed early, would have been addressed aggressively, and they would not be dealing with this outcome that they are now. So, it's too bad, but we live and we learn. And if nothing else, this is definitely educational for all of us. And I hope that this podcast was educational for you as well. So on behalf of myself, Pat the Man Santos, Nick Bonds, and the entirety of both the FIA group and this industry and those that we serve, which is pretty much all these hardworking plan beneficiaries, their families, dependent spouses, that they're really looking to us to do the best we can. Hopefully this helps you do just that. So on behalf of myself and all those indeed, thank you very much for joining the FIA group for another Empowering Plans podcast. Be well.